As a statistician, I appreciate that lawyers might not be interested in that, but I've worked for nearly 40 years in medical statistics, and from what I can see, I don't yet have the evidence or the information available to me to say that the implicit statistical statements, and there are many, are justified.
Thanks so much for being with us. It is Kate Borsay. It is the evening edition here on Times Radio. If you haven't downloaded it yet, the Times app is the best way to discover all the award-winning reporting and commentary from the Times. It's easy to download, and as a digital subscriber, you'll get full access to our stories, features, interviews and puzzles. It is easily my most used app. Probably not a surprise. Just head to the App Store or Google Play and search for the Times to access that. So it is the evening edition, 8:36 here on the show. Let's dig into now a pretty contentious inquiry that's starting tomorrow for a number of reasons. And it will examine exactly what happened at the Countess of Chester Hospital during the time Lucy Letby worked there. The inquiry will investigate how the NHS handled the case and its response to doctors who raised concerns. It's expected to last around 4.5 months. I'm joined now by a couple of people close to this story. Jane Hutton, who joined us on the show last week, actually. She's been calling on the government to postpone, along with other medical experts and people within her field. She's a statistician from the University of Warwick. She's calling on the government to postpone or change the terms of the public inquiry over concerns about the conviction and the data used. And Joshua Rosenberg, KC, legal commentator. Evening, Jane, to you.
Good evening.
And evening, Joshua, to you.
Hello.
Jane, let's just set out your case. Obviously, this inquiry now hasn't been postponed, but there's a call for its scope to be widened. Would you advocate for that and just explain to our listeners why that's so important?
So there are a lot of parents who've suffered the tragedy of losing their babies, including other parents at the Countess of Chester Hospital during the time that will be investigated. But those deaths are not currently included in the scope of the inquiry, and that limits the possibility of learning lessons from all those deaths. The Royal College of Paediatrics and Child Health report into the problems listed, I think 23 points I counted, listed in the Telegraph. That is a lot of problems which, as far as I understand, and I might be wrong, are not within the scope of the inquiry.
And Jane, this is a slight repeat of our conversation last week, but I think it's important to say there are concerns over the data that was used in the conviction of Lucy Letby.
That is correct. I've now had time to work through part of the appeal court judgment. And one of the things that has particularly struck me is that the error that was made in the Sally Clark case is repeated, except, of course, it's rather worse than in the Sally Clark case. Paragraph 144, and the coincidence of other babies also suffering sudden collapses, most strikingly in cases of twin siblings. And then you get, and the fact that siblings suffered harm at or about the same time as each other. That is very worrying to a statistician, because to call that striking is to implicitly say it's got a low probability, and in fact it would have a very high probability. I would actually, having collaborated in research on premature infants, I would say I'd be rather more surprised if the infants didn't have collapses, serious ill health at the same time than if they did.
Sally Clark.
There are plenty of other issues that concern me now that I've worked through the transcript.
Okay, well, maybe we can dig into a few of those. I spoke to you this time last week. Of course, you'd only started to be able to have a look at some of that. Sally Clark, we should say, was the mum, that solicitor wrongly convicted of murdering her 2 baby sons. She had her convictions quashed by the appeal court. Joshua Rosenberg, what is your perspective on this case? What we get from tomorrow is the beginning of oral evidence into the Countess of Chester Hospital. The inquiry has a limited scope. I suppose it's about looking at what might have happened, deficiencies within the unit to a point, and lessons to be learned for the future. But all the while, overhanging it are some serious questions about whether the conviction of Lucy Letby for murdering those 7 babies, whether that conviction is strong enough, whether it can be upheld on evidence that is strong enough in retrospect?
Well, it has been upheld, as Jane says. It was upheld by the Court of Appeal a couple of months ago, obviously not just on the evidence of statistics that she's referred to, but on all the circumstantial evidence that was brought before the jury. Now, it is possible, obviously, for a case to be referred to the Court of Appeal a second time if new evidence comes forward, but that's not the job of this inquiry. This inquiry starts on the premise that Lucy Letby was correctly convicted, that she is guilty. It doesn't look at what happened at her trial, doesn't look at the jury's decisions, it doesn't look at what the Court of Appeal said. It goes further, I think, than you've described. It looks at the experiences that the parents had at the Countess of Chester Hospital. It looks at the conduct of those working at the hospital who dealt with Lucy Letby. That includes whether suspicions should have been raised earlier, the response from hospital managers, whether the trust culture, management and governance contributed to the failure to protect the babies, and the effectiveness of NHS management. So it's quite a broad inquiry, but certainly it doesn't try to interfere with the criminal justice process.
Okay. I mean, Jane, I had spoken to you about concerns about whether the conviction of Lucy Letby was safe or not.
Yes.
And from a statistical point of view, you had concerns about that.
So the concerns include the fact, so if you look at the alleged causes of death, or if you even start at the beginning, where you get the statement in the Court of Appeal judgment, the applicant alone was present on the unit at the time of all the deteriorations and deaths. We never get a satisfactory definition as to what was defined as a sudden and unexpected death. Now that, as I say, is essentially a statistical matter. Further, then we also get the problem of, if you're trying to assess whether a diagnostic method is reliable, you're talking about sensitivity and specificity. That's essentially statistical. There are international standards on how you can assess that. And from what I've read so far, there is nothing that meets anything like those international standards of evidence-based medicine. Got the same problem with the insulin, got the same problem with the swipe data, miscoding, but not even that. There are assumptions that are being made that coding, that the swipe data accurately represents who is on the ward. But we've all used cards and more than one person's entered. We've also got the question of, how rigorous, exactly what procedures we're following in starting with 61 cases and reducing them down. And as a statistician, I appreciate that lawyers might not be interested in that, but I've worked for nearly 40 years in medical statistics. And from what I can see, I don't yet have the evidence or the information available to me to say that the implicit statistical statements, and there are many, are justified. I noticed that a number of lawyers have said, there's no statistics or probability in this. With all respect, if I started to tell a lawyer, as a statistician, what was or wasn't a legal matter, I think they would ask on what basis I was saying that. I would like to think that the Royal Statistical Society is entitled to a view on what is or is not statistical evidence and what is or is not good quality statistical evidence.
Joshua, come back on that. There are questions about the quality of the statistical evidence. You heard what Jane has to say there about the difference between, I suppose, what meets the international standards on statistics, on data, and the sort of threshold you need to meet, or the robustness of that, versus the legal interpretation of this.
A lot depends on how the defence choose to put their case. It's been noticed by everybody that the defence team acting for Lucy Letby chose not to call any expert evidence. Now, they may have had reasons for this. We don't know what they are because privilege has not been waived, and so we can't ask them, and they very properly won't tell us. It is significant that Letby chose to use the same legal team at her retrial, and there was again no questioning of the statistical evidence at the retrial. And the courts assume that if you have lawyers, senior lawyers, KC, representing you, then those lawyers will act in your best interests. And they assume also that the jury who sits through the case will weigh up the evidence, decide the significance of the statistical evidence, of the circumstantial evidence, of the notes found together with the papers that Lucy Letby took back from the hospital against all the rules and hid under her bed, the notes which appear to be a confession. The courts will assume that the jury looks at all of this and comes to an overall conclusion. As we know, some of the charges were proved, on some they couldn't agree, and that's why there was a retrial.
Is the issue here, Jane, also that because we've had a very high-profile legal case, that and then questions about Lucy Letby's conviction and how safe it is and what data has been used in her defence or otherwise, is the issue here that because that is a very current subject of debate and it's extended into social media, amateur sleuths and all the rest of it, is there a danger that that then overshadows the inquiry, or will the inquiry be all the richer for some of those questions being asked, even if they're not asked within the inquiry, the fact that statisticians like you are asking them away from the inquiry at the moment, will it only benefit from that, or could it sort of hinder the good work that the inquiry could do?
So the Royal Statistical Society published their report on clusters of healthcare deaths in October 2022. And at the time, I was the chair of the section. At the time, we planned to do a launch meeting, but we didn't want to launch it while a current case was still ongoing. If you look at my webpage, which is where people can express interest in the meeting that we'll be having, it doesn't mention any individual. We're launching a report into something that is very important. We have been working for 25 years and more, but 25 years since Sally Clark, with the legal profession. We've published quite a number of guides. We've had quite a number of collaborative meetings. I'm holding 4 workshops, interdisciplinary workshops this year. Almost every lawyer whom I've met, judge, barrister, solicitor, almost all have said to me they are frightened of or not confident of or not competent in statistics. And the Royal Statistical Society, Stats in the Law section, wants to work with the legal profession, the justice system, to improve statistical literacy in the interests of justice.
Joshua Rosenberg, would you concede that too, that the legal profession isn't maybe as confident as it should be working with statistics?
I think the legal profession has a lot to learn from all scientific disciplines, and there are efforts made by the Royal Society, for example, among other bodies, to bring lawyers and scientists, and for this purpose I would include statisticians, together. We can all learn from one another. There was a particular medical expert who was consulted by Lucy Letby's defence team, who couldn't understand why he wasn't called to give evidence. There is, as he rightly said, a way in which the lawyers and the experts, scientists or other experts, do seem to live in different fields and don't really understand how the others work. And so, yes, bringing those together is very important. But it's also very interesting, if we're talking about the inquiry tomorrow, to look at what Lady Justice Thirlwall, the inquiry chair, has said about conspiracy theorists. I'm not suggesting for a moment that any of the scientists who've given their views on this are conspiracy theorists, far from it. But nevertheless, one of the arguments put on behalf of the parents for the inquiry to be live streamed, an argument that was rejected by the inquiry chair, Lady Justice Thirlwall, one of the arguments was that not allowing live broadcasts will hand to conspiracy theorists a sense that there is hidden information, and it will lead to increased speculation and worsen those theories. And the inquiry chair said she understood that how the parents felt, and it wouldn't make any difference whether she directed live streaming or not. But the idea that live streaming would reduce or dispel toxic and offensive conspiracy theorists was unsupported by evidence, and she rejected it. Thirlwall said that searching for truth is not a characteristic of conspiracy theorists. Like those who promulgate fake news, they search for information which supports their worldview.
Look, thank you both of you. Sadly out of time on this, but it's been really interesting to hear both of your perspectives, some of which aligns, of course, and some of which just useful to put out there as we start to think about what might be achieved by this inquiry and some of the problematic nature of the Lucy Letby case. Jane Hutton, thank you to you, Professor of Statistics at the University of Warwick, and Joshua Rosenberg, KC. Thank you both for joining us.